Our next speaker is a graduate of Rutgers University and went to Stanford School of Law. Following graduation, he clerked in the United States District Court and later clerked for an Associate Justice of the Alabama Supreme Court. He's very active in the legal community. He's a fellow of the American Trial Lawyers, International Academy of Trial Lawyers, and the International Society of Barristers, just to name a few. He is a past president of the Florida Bar, Florida Board of Trial Advocates, and the Miami Obota chapter, to name a few. He's been an adjunct professor of law teaching trial advocacy since 1984. And he also has been continuously selected as one of the best lawyers in Florida by various publications. He has won and received numerous awards, to name a few: the Justice Harry Lee Anstead Professional Award, the B.J. Masterson Award for Professionalism, and the David Dyer Award for Professionalism. And the list goes on and on. I had the pleasure of co-trying a case with your next speaker with Stewart in 2010, and I have never seen a harder working lawyer. Close to midnight about every night, there he was with a yellow legal pad, around day 13 or day 14 of the trial, with a yellow legal pad, mapping out every possibility that would happen at trial. And you would think a guy who's been doing this 34 years, president of the Florida Bar, and all the awards he's won, he'd probably have a team of people to do this. But not our next speaker. He was committed to this case so much that every night he was there, constantly worrying about every little possible detail. And it was that dedication I saw, and I actually learned a lot by watching his commitment that even when we're all 50, 60, 70, and 80 years old doing this, we still have to have the commitment that our next speaker had. When Herman, who I'm going to introduce, was the president of the Florida Bar, was described by somebody, he was once described as a 48-hour dynamo with a heart of gold. So it's my pleasure to introduce our next speaker, Herman Russomanno.
Thank you, Scott, for those kind words, and good morning, everyone. It's a pleasure to be with trial lawyers. I'm proud to be a trial lawyer, and we learn from each other. Stewart, thank you for the kind invitation and the daily business review for us to be here together and to learn and ask questions. My topic, we're talking about commercial arbitration, but we're all trial lawyers. So the purpose of the talk will be to, when we engage in this process, how do we maximize our ability to represent our client? How do we maximize our recovery? Or if we're on the other side, how do we either get an outright decision in our favor or minimize the damages that your client will pay? Stewart, in his excellent talk a few minutes ago, talked about jury selection and cross-examination. And if you really look at the arbitration process and talk about cross-examination just for a moment, and it's been described, I think John Henry Wigmore described cross-examination as the greatest legal invention ever discovered for the purposes of truth. And Dean Roscoe Pound was a little more colorful when he described cross-examination as the slaughterhouse of reputations. If you really look at the arbitration process, you really don't have transcripts, so to speak, with regard to cross-exam. Very, very rarely do you have the transcripts unless it's to be presented at an arbitration proceeding because a witness cannot attend. And jury selection, because I agree with Stewart. Jury selection to me is the most important part of a trial. And speaking of Key West and what he and Raleigh went through, I know in my first trial in 1977 in Key West before Judge Julio Gomez, and both lawyers, young lawyers at the time, were from Miami. And we're asking questions of the panel, and everybody, of course, knows both of our clients. So we're looking, it was a smaller community back then. So we're perplexed, and the judge calls us up, and he says, "Gentlemen," he says, "you look so surprised that the people know your clients." He says, "what you need to concern yourself about is what they know about your clients." So that made us understand that. But in arbitration, jury selection, because neutrality is paramount. If you really think about the proceeding, and we're here today to talk about what are the strategies and techniques when you have to be in arbitration and you're going to proceed. The outline, and there's some excellent materials in this outline. What we've done, and we won't cover that today because of the time, but when you want to attack arbitration, when you want to have all the cases that will be talking about arguments such as jury waiver, contracts of adhesion, how you go about attacking it, making your record, making the constitutional attack. That's all in the outline. And it lists it all of it. And you'll have tables, and there's some excellent articles there. But what we want to talk about today are, when you're in the process, how do you work with it, and how do you deal with it properly. I mean, there's so many outstanding attorneys in this audience, both trial and appellate, that I've known for many, many years. But just to get a feel, how many people, say, have done 25 arbitrations or more in, say, commercial? Or 10? Or 5? How many have not had an arbitration in commercial? All right, so let's just talk about the whole process. If you're going to meet with your client, an arbitration will take place. You then need to determine whether it's going to be in state court or federal court, if that option exists. Clearly, if you can be in state court under the Florida Arbitration Code, Chapter 682, you want to be there. Even though you would like to avoid arbitration, if you're there, you should try to do the best of it, because it's an easier process than if you're dealing with the federal statute. And I've listed that in the book as well. But what's the first thing you want to do with regard to thoughts that go through your mind? You're having arbitration. Do you want a soloist? Do you want a panel? What are the pros and cons of each? And if you do go with, say, a single arbitrator, what's your jury duty workup on that individual? Because let's face it, if you don't have neutrality, you can talk to your blue in the face. Doesn't mean a thing. So when you really have your tools in jury selection to go through the process, you even have a greater responsibility when you do the arbitration selection. And whether we're working with the AAA, whether we're working with FAGNET that does the securities litigation, you have to make that decision. How do I go about doing my due diligence in the selection of an arbitrator? And what will happen is you'll be provided with sometimes lists, sometimes you'll know the person. But even though you may know the person, and of course you need to know thy opponent, you need to know who's on the other side, all the ingredients. What do you know about this individual? Because an arbitrator, like jurors, bring their life experiences into the room. If someone has in front of an arbitrator, and say he or she has done certain type of work for 30 years, and represented certain types of clients for 30 years, those are not left outside the arbitration room. They're brought in with the individual. You need to know that. You need to, first of all, check not only the person's background, because you may know the person, sometimes you may not, but what arbitrations have they been involved with? Let me read some of their awards. How have their arbitration awards been written? Is there a tendency as to how the arbitrator has decided cases in the past, either alone or with a panel? Then you do your Westlaw search. You want to find out as a trial lawyer, how many? Some arbitrators have never seen a courtroom. Others, some of us are arbitrators, mediators. We don't use it. We represent clients. Occasionally we'll sit if it's for some special people and you're asked to do it. But you have to understand what's the makeup of the person. Then once you get the names and you see the awards, and some are confidential, others of course have to be filed with the court. You want to call lawyers that have arbitrations in front of those people. What's been their experience? What are the tips you need to know? And you have to take it seriously. I've seen people's cases just blow up because they didn't spend the necessary time in arbitration selection. They just sort of felt, move the process now, let's get some dates, let's send out some discovery. And the most important part of the arbitration proceeding was arbitrator selection. So every single ingredient that you can put into the jury selection process, you have to do the same, if not more, with arbitration. And then you have to make a decision if you're going solo or with a group. What type of case do you have? If you want the type of case, whether you're defending or where it's a winner-take-all, and not the split-the-baby type of case, Well, you may think about a soloist, because a person could be dogmatic, they've ruled. You know, again, how will that person rule? How's that person's background? And every case obviously has its own facts, but you're trying to put yourself in the mind of your client and say, which way do we go here? Also with cost, let's talk a little bit about cost. There is and again, it's a falsehood. People try to portray in this country arbitration, much less expensive, inexpensive process, court, too expensive. It's a lot of bull. It really is. And I can just tell you this, we represent a lot of different people. We don't do insurance defense, but our tort practice is like everyone here. And then on the end, we represent commercial clients. And I can tell you whether it's the Trump Corporation, Donald Trump, other people, developers, they don't like arbitration when they're fighting against other big people. They're like us. They don't like limits on damages. They don't like any curbs. They want to have the court process there ready and available for them. When is arbitration liked in this country? Well, most of our life, if we look at what we do, we want to buy a car, buy an insurance policy, get a credit card, open a bank account. You see these contracts? Arbitration is in there. You may not know about it, but as to the consumer, the corporations, they love it. They love it because they want to limit recovery. They like it, you can see in class actions, and there's a case in the outline, AT&T Mobility, where the United States Supreme Court, and we have the side in there, just basically blew up under a preemption argument with regard to consumer class actions dealing with cell phones. So when you look at the makeup of what's the process, big corporations fighting each other, they despise arbitration. They don't want to be limited in what they could recover. You get cases sometimes that are worth $500 million, $1 billion case, all the way down. They want full recovery. So going back again to arbitration selection. Arbitrators typically, either if they bill by the hour or by the day, you can talk about anywhere between $4,000 to $7,000, the good ones. If you have a panel, the neutral, you all split, and then the others, you pay for your own. So you're talking about an expensive process. And we'll talk about then what you have, what are the advantages, and what are the disadvantages. But if, say, you have a case where you feel, look, this case could go either way. I don't believe, if, say, we're on the plaintiff end for a moment, that we're going to lose liability. But damages could be questionable. Or if you're the defense, to say, look, I don't think I'm going to win this outright. But I need to lower the expectation of recovery. So now you pick your own arbitrators. Even though we want to use the term neutral, you hope that advocate, obviously you have to have a persuasive case, but you hope that advocate's going to be a good juror for you. Because the two should be the opponent and the others, if they're doing their job, and I mean acting fairly, they should be hopefully seeing the case, even though they want to look at it in a matter, are they predisposed just ever so slightly toward your case? How persuasive are they? What effect do they have with the neutral? What experience do they have with each other? Have they been on panels before? What's been the success rate? So all these important questions are critical when you make that decision. And then, of course, the expenses rise if you're using a 3-person panel. So you have to understand that as well.